afternoon, officially. My name is Kara Boaf, and I'm the Senior Director of Planned and Major Giving here at Kettering University. And with me is my colleague, Lori Shively. Lori is the Director of Individual Giving, and she holds a law degree from Michigan State University. Before joining Kettering University last September, Lori spent over 10 years helping people prepare their wills or trusts. And joining us on the Zoom call today is our colleague, Dave Tyndall, who, like Lori and myself, help Kettering alumni and friends make financial gifts to Kettering University. Preparing for the end of life is one of those things that we know that we should do, but not everyone has done it. In fact, according to a recent survey by Caring.com, only 32% of American adults have a will or a living trust. If you are 55 and older, that percentage is slightly higher, nearly 48%. Yet we are, as a country, in an unprecedented time due to the COVID-19 situation. And nationally, we have seen a significant spike online in preparing one's will or trust. It seems that there is now an increased effort and interest in making sure that the paperwork is in order in case of the unexpected. And that is why, with Lori's expertise, we decided to hold this presentation for Kettering alumni and friends. We've called it Leaving a Legacy, Introduction to Wills and Trust. We're going to describe what is a will, what is a trust, and also we're going to describe how to leave an amount of money or property to someone, a family member, a dear friend, perhaps even an organization or a charity that you're connected with, a church, a community group, your alma mater. Our goal is to provide information, not offer legal advice. The first half of the presentation will be an interview between Lori and myself, followed by time for your questions. We encourage you to grab a pen and paper, and as you go along with us, type your questions in the side panel, which will be opened up shortly. Lori, are you ready to begin?
Yes, I am. Thank you.
Great. Let's start with the big question. What is a will and what is a trust?
Okay. So both a will and a trust are estate planning documents that are designed to leave your assets to people and organizations that you choose. A trust is similar to a will. However, it's a private document that doesn't get filed with the probate court. And many people prefer a trust over a will for that reason. The only people who have access to know what's in the trust are the beneficiaries and the trustee. Additionally, the trust can offer certain protections, such as providing for someone with special needs or arranging to have a family pet cared for. Many of us have had friends or family where not everyone gets along. So when a will is filed with the probate court and made public, any person can look at what's to be distributed to other people, which may cause the estate to be delayed if someone thinks that they deserve a part of the estate. On the other hand, the trust remains private and it's not open to public. With a trust, you can choose to leave your beneficiaries money in increments. For example, leave them half of the balance of their inheritance at 25 and the other half at 30 after you provide for their education. A trust is effective when signed, unlike the will. And all these things make it easier on those who survive you at a time that's very difficult and stressful. You're assured that your loved ones are taken care of quickly and efficiently without the need for time and financial constraints required by a probate court and possible challenges against the estate. So a will is a simple document that's usually used by people with few assets and by people who need to designate a guardian for minor children. The personal representative or the executor is designated in the will to carry out your wishes and pay the final expenses of the estate. At the time of your death, a will has to be filed with the probate court and the terms are made public. In addition, a file in probate court is required to be opened and a number of procedures are required before the estate can be closed, including payment of costs and fees, which can be substantial depending on the size of your estate. The time frame for completing the estate can also be lengthy.
Great, thank you. You know, I often hear family and friends say, I don't own much. I have just a house and some bank accounts. Why do I need a will or a trust? Why should I spend all that money to make a will or a trust?
Well, even though you may think you don't have a lot of assets, you probably have more than you think you do. if you own a house, you have equity in the house, even though you might have a mortgage balance. You have personal items in the house that you will want to give to certain people. You probably have checking and savings accounts in a car or any other type of vehicle. All these assets should be distributed to the people that you want to distribute them to, which is done through the estate plan, either the will or the trust. For example, let's assume you're single with no children, no siblings or parents, and you own a house and a checking account, a savings account, and a car. In Michigan, if you pass without an estate plan, the court's going to decide how the assets get distributed, which in this case may end up going to cousins that you've never met instead of friends or charitable organizations that you would have chosen to receive these bequests.
Okay. So when does the will take effect? And the same thing for a trust. When does that take effect?
So the will is only effective on death. And until then, there's no beneficiary is entitled to anything. You can revoke your will or amend your will anytime you want. Powers of attorney can operate in the event that you're not able to conduct business or make medical decisions for yourself, and they're normally prepared at the time you have your will or trust prepared. So a trust, on the other hand, is effective as soon as it's signed, and it does not need to be filed anywhere. You're the original trustee. You can do with your assets whatever you want. You can revoke or amend the trust at any time. And if there's a certain time period that you can no longer act as a trustee, maybe due to incapacity, or you simply don't want to manage your own finances anymore, you have a successor trustee that can step in and take care of the trust. And then when you pass, the successor trustee takes care of finalizing your estate. Powers of attorney are usually also prepared at the time that you do a trust.
Okay. When should either a will or a trust be changed after it is completed?
So best practices dictate that your estate plan should be reviewed at least every 5 years, or when there's some type of a life-changing event. So if you have children that are graduating from college or getting married, or if you remarry, or you decide to retire, those are all good times to take a look at your estate plan.
Okay. So what if I live in one state and have property like a winter home in another state? Do I need to do a will or a trust in that state too?
No, a will and a trust are governed by your state law, and each state has specific requirements in the way that their property is titled. You should only have one will or a trust, and that's to be prepared in the state that you reside in. So if you have property in another state, like say you have a home in Florida, your attorney is going to contact a licensed attorney in Florida who's going to prepare the correct documentation for the transfer of that property.
Great. You know, Lori, we started our conversation with me noting about the increased online searches for wills or trusts. Why can't I just go online and prepare my own?
So some people have inquired about using online resources and not spending the money on an estate planning attorney. The thing that you need to understand is that you're not getting comprehensive legal advice, which may end up having an undesired effect and cost your estate money in defending a lawsuit. But many of the online companies will have a disclaimer that says they're not providing legal advice, but in fact are only providing forms specific to your state and information on how to sign them. And although it is originally more expensive to hire an estate planning attorney, it's definitely worth the cost in the end. When you meet with an attorney, they're going to ask you about your family. Is it a blended family? Does one child handle money better than another? Do any children have spousal or creditor problems? Do you own a business? And if so, how is it managed? So it's always best to have an attorney that practices in the area of estate planning. Prepare your documents because the laws change frequently, and the exact wording specific to the transfer of assets can have consequences. For example, Michigan, there are 3 ways you can title residential real property. And if you try and prepare a deed on your own, you might miss some important wording, which then requires the property to go through probate court. So if you own a summer home and you want to leave it to your 3 children, you want to tell your attorney how you want the children to own it. Do you want them to all own it jointly, or do you want them each to own a 1/3 share? And that's going to make a difference on how they prepare the document.
Can you describe what it means to fund a trust?
Sure. So before we get into the funding of the trust, let me explain the difference between assets that need to be probated and non-probatable assets. So when you pass, any asset that does not have a beneficiary designation is considered an asset that needs to be probated through the court system. For example, if you have a house only in your name, that would need to be probated. A non-probatable asset is an asset that has either a direct or a contingent beneficiary, and it avoids probate by going directly to that beneficiary. For example, your life insurance policy would list your spouse as a primary beneficiary and then your children as contingents. Your goal in creating an estate plan is to leave your assets to people that you choose, not to the people that the court has to decide on based on your state statute. When you create a trust, your goal is to have all of your assets either titled in the name of the trust or have the trust listed as a primary or a contingent beneficiary. This way, when you pass, all of your assets pass through the trust and don't go through probate court. For example, if you and your spouse have a 401k or an IRA, the spouse is going to be listed as a primary beneficiary, which is usually a plan requirement. And then the trust would be listed as a contingent beneficiary. So when the second spouse passes or both spouses pass together, the trust then owns the account and it gets distributed according to the terms of the trust and how you want it distributed. So as far as the funding, some attorneys will prepare all the funding documents and others are going to give you instructions on how to prepare the funding documents yourself. And the funding documents simply are change of beneficiary forms. So a change of beneficiary for your 401k and your IRA. It's always best to know during your conversation with your attorney how they're going to handle the funding. And if you have a financial advisor, you'll want to work with your financial advisor to let them know you're doing a trust, because they have the proper forms and can help you prepare the change of beneficiaries for your accounts.
Okay. So what about any real property that someone owns, such like a house or a vacation property? Does that get titled in the name of the trust?
You can title your house or other property in the name of the trust, or you can do what's called a ladybird deed, which is otherwise known as a life estate deed. You do need to check with your attorney on state law. Michigan and Florida recognize a ladybird deed, which means the house stays in your name until you pass, and then it's transferred directly into your trust. Your trustee manages the property, pays the bills, prepares it for sale, and then does with it what you have directed him to do. I've had questions about simply adding a child or children's name to your deed to your house, therefore wanting to avoid probate when the client passes.
Mm-hmm.
But this can open up a number of issues and problems, including what happens if your child dies before you. That property can then become part of their estate, because when you add their name to the house, they own the house jointly with you. And it also means the child or the children have to sign off on a deed if you want to sell it or remortgage it. And the property would be subject to any creditor or bankruptcy issue your child might have. So these type of things are avoided with having a ladybird or other similar type of deed transferring the property to the trust when you pass.
You've mentioned a couple of titles for people who are listed in a will or a trust. Can you describe for us the difference between a personal representative, an executor, and a trustee?
Sure. The personal representative is also called an executor, and that's the person that's named in a will but carries out the wishes of your will regarding the distribution of property and paying your last expense. The personal representative has no power and cannot act on anything until you pass. The trustee is a person that's named in a trust who handles the financial affairs of the trust, and the trustee may act before your death. When you create a trust, you are the original trustee and you are the original grantor. And the grantor just means you're the person that's creating the trust and that you own the trust. So a couple other designations are guardian. That's a person or persons who physically take care of a minor child and they're named in the will. And the testator is the person who creates and signs the will.
Okay. What paperwork should I bring to the attorney's office, whether I'm going to have a will or a trust set up?
So an attorney is going to want to do an analysis of the assets that you have in order to prepare an estate plan for you. So it's going to help them if you're prepared with a list and copies of statements for your checking and account savings and who actually owns those accounts. Sometimes they're joint with spouses and sometimes, each spouse will have their own. Your IRA statements, your retirement accounts, 401ks, pension information if you have a pension, deeds to your property, and then any information if you have a business or if you have an interest in a business. And also if you have stocks and bonds, they need to know that. This will help an attorney get an idea of your overall net worth, and he can address any potential inheritance tax issues if need be. So they're going to also need the names of and addresses of your children and your beneficiaries, and your executor and guardian or personal representative. And only when they have a complete picture of what you own and how you want your assets to be distributed, then they'll prepare a comprehensive estate plan for you. At the time they prepare a will or a trust is a good time to also do the medical and financial powers of attorney. And most attorneys will do that as part of the estate plan. The powers of attorney are only effective when you're alive and allow your agent, which is typically a spouse or an adult child or one of your siblings, to act in the event you can't act for financial affairs or medical. The powers cease on death, and they must be signed while you're competent and able to know what you're signing.
Lori, we often receive calls from folks who want to make a gift to Kettering University or other charities, but they can't do so now because of certain situations in their family or such. Can you describe how to make a gift in a person's will or trust?
Sure. Someone can make a planned gift through a will or trust to be distributed after they pass. So in this event, they're able to keep their current assets to help support themselves and their families now and to provide for the charitable organization of their choice with a future gift. There are a couple of ways to establish a gift through a will or trust. The first one is to make what's called a specific bequest. Mm-hmm. That means you can leave a certain amount of money or assets or a percentage of your estate to a charitable organization, such as Kettering, upon your death, and then the remainder of the estate can be distributed to other beneficiaries directly, or it can be held in trust to support those beneficiaries. This gift is distributed by the trustee pursuant to your instructions without the need for probate court. A second way to accomplish this is that a charitable organization is named as a direct beneficiary of certain assets, such as a 401k or an IRA, and then those assets pass directly upon your death. Another way to leave a legacy is to make a blended gift. You could leave a charitable organization a partial gift, for example, towards a scholarship in your name or a family name, and also include this organization in your estate plan to add to your gift after you pass. I understand this is a lot of information to think about and to prepare for, but it avoids potential conflict between family members, and it truly takes an incredible burden off the people you love in finalizing your estate. Once you've decided where you would like your assets to go and you gather the paperwork, it's a simple process to meet with the attorney who then prepares all the documentation and then obtains your signatures.
Well, thank you, Lori. It was very comprehensive. We're now going to open it up for questions. Why don't we have folks enter into the chat room and type a question to us if you have one of top of mind. These are one of those rare moments where you get to consult with an attorney without it being a billable hour. From David, I have the question, why do I need a will or a trust?
Because you want your assets to pass the way that you want them to. And sometimes people think that even if they are doing direct beneficiaries on everything, say you've got a beneficiary on your IRA and your 401k and on your checking and savings accounts, there's the possibility that eventually you will obtain another account or another insurance policy and you'll forget to name a beneficiary. So at that time, that asset's going to have to be probated. And like I said, it may not be going to the people that you want it to go to.
Okay. A couple of other questions here. I have been hesitant to complete the process. Is it really that difficult to do?
To complete it, it's really once you meet with an attorney and they're gonna get an idea of yourself, your situation, your family, and you get the documents together from them, then they're gonna take some time and prepare the estate plan for you, give you a draft of it, and then you go in and sign it, and then you're done. There's nothing else you have to do. Everything is taken care of. You just have to review it periodically.
Okay. We have a question from Jeff, and his question is, what are the advantages and disadvantages of an irrevocable trust?
Well, so the irrevocable trust is just what it says. It's you create a trust. You can create an irrevocable trust. You cannot make changes. Normally, you cannot make any changes to an irrevocable trust. They are good in some situations. Most, if you're just creating a trust, most of the trusts are revocable grantor trusts, but there are specific situations where an irrevocable trust works.
Okay. We also have a question about this presentation today and whether or not we can forward it. Our intention is to make it available, and so we will either present a slide deck for you or the recording of today's presentation. And if to leave a gift to Kettering, as Lori mentioned, it's quite easy. You can specify how you want the gift to be used at Kettering. She mentioned scholarships. That's very, very popular. Many of our alums want to kind of pay it forward for their next generation. And you can include even preferences for a geographic area, gender, or a major, or all of the above. So we encourage you to contact us. We'll list our phone number at the end of the presentation, and we'll work directly with you if you need some language for your presentation, for your conversation with the attorney. There was another question here about the final presentation point regarding changing as life events change. Is that enough for you, Lori, to discern what that question means?
Yeah, so you always want to take a look at, and I hope I'm answering this right, so let me know if I'm not. You always want to take a look every 5 years and make sure that your life is the same way, that everything is, review your documents and make sure that you're leaving things to people that you want to leave them to. And when life events change, like say some people get remarried and they're going to have a blended family, they're going to want to discuss how they're going to leave their assets to children, the children combined or separate children. So if that's not the right answer, I'd be happy to expand.
I think that looks like it's the right answer for that person. I don't see another one coming in. Do we have any other questions? Well, thank you. This wraps up the Q&A portion of the presentation. And before concluding, I do want to add that when we do speak with the Kettering alumni and friends who are making or updating their will or trust, we understand that the #1 priority is taking care of your family. We consider it a tremendous honor if you are thinking about making a gift to Kettering, and we ask that you contact us so that we can provide you with the correct language to include in your legal documents. By letting us know about your gift, you will be included in Kettering's Heritage Society, which is a donor society that recognizes alumni and friends who leave a bequest or make another type of a plan gift to the university. It's a special group of people who have made it their legacy to ensure that the Kettering education goes on for future generations. We hope that we've answered some of your questions regarding estate planning and how to plan for the future. Again, it's important to consult with your financial advisor and an estate planning attorney. And whether you end up with a will or a trust, it is critical that you have the right documents in place to carry out your legacy. Lori, thank you very much for clearly presenting the options for a will or a trust. And I thank everyone for joining us in today's presentation. Please feel free to call us with your thoughts or questions, including what you thought of this presentation or topic ideas for future presentations. You can reach us at 800-955-4464. That's 1-800-955-4464. Again, thank you. We look forward to hopefully seeing you real soon.